If you're being contacted by a debt collector, you have rights. Debt collectors must follow a certain set of rules that you can find in the Fair Debt Collection Practices Act. Let's talk a little bit about those rules. First, let's talk about what happens when a debt collector contacts you. They have rules they must follow in contacting you. First of all, they can't call you at any time or place that they know to be inconvenient. If you've told them a time or place that you cannot take their calls, they have to abide by that. Second, they can't call you before 8 a.m. or after 9 p.m. And they can't call you at your place of employment if they know or have reason to know that your employer does not allow you to take those calls there. And if you're represented by an attorney and they can find out the name and number of your attorney, then they can't have any direct communication with you as well. How about third parties? Sometimes debt collectors like to call third parties. Now, a third party is anybody except your spouse, such as neighbors, other family members, children, or good friends, or other people at work. They can't contact those people except for the limited purpose of trying to find your location information. The collector has to call them and tell them simply that they're looking for location information and nothing more. They can't tell them anything about the fact that they need to leave you an important message or this is regarding an important business matter. The debt collector also can't tell that person anything about the fact that you may or may not owe a debt. And they can only contact that third party one time. Unless, of course, they have reason to believe that the information they got was false, they can try again. But otherwise, they can only contact each third party one time. Also, debt collectors cannot commit any form of harassment or abuse. They can't commit any conduct, the natural consequence of which is to be harassing, abusive, or oppressive. They can't swear at you, scream at you, call you names. They have to tell you who they are. They can't hide what their name is. They can't hide the true purpose of their call. They can't make any misrepresentations to you. A debt collector has to tell you the true amount of the debt, and they can't ask for more money than what's really owed. They have to tell you the true character and status of the debt. They can't tell you that a debt is in lawsuit or they're about to sue you when they're not. They can't tell you that they're a lawyer when they're not a lawyer. And they can't tell you that you've engaged in criminal conduct when you haven't. And a debt collector cannot do or threaten to do anything to you that they know they legally cannot do or have no intention on doing. In addition to that, a debt collector cannot commit any acts that are unfair or unconscionable, such as threatening to publish your name on a list of people who owe debts, or demanding that you give them a post-dated check only to deposit that check early. They can't do that as well. And if a debt collector decides to sue you, they can only sue you in the county where you reside or in the county where the transaction that led to this debt originally occurred. You have rights under the Fair Debt Collection Practices Act, and if you come upon a debt collector that has committed any of these acts, call us at SmithMarco. We handle Fair Debt Collection Practices Act cases.